We're going to talk about is trademark review of refusal practice in mainland China, and it's very nice to have this chance to communicate with all of you here. And our meeting will last around 1 hour, and I will try my best to shorten the time. And after my sharing, I will leave some time for asking questions. Okay, let's begin. Firstly, I'd like to give a brief introduction for myself. I'm Frank Zhang, trademark attorney, graduated from the Law School of National University of Singapore. I used to work in Untitled with Lily Qin and Dan Chen for several years and joined Gaowo last year. I've been working in the trademark field for several years and provided professional services for many world-leading companies, such as Visa, Le Mans, the car racing service provider, Lancel, the luxury bag brand, Mac Amiri, a famous a luxury clothing brand from America, etc. Actually, I mainly engaged in the trademark prosecution, including the new application, review or refusal, opposition, invalidation, non-use cancellation, and other consultancy work. In practice, I also have my clients to analyze trademark infringement and handle trademark administrative litigation, as well as other trademark disputes. As per today's plan, I will talk about a trademark review from the following three aspects. And the first one is what do the examiners review when they receive the new application? Namely, what they will examine. In this part, I will briefly introduce the quantity of new filings in recent 5 years, procedure of new application, and what the examiners exactly review in the new application. And the second topic is about why we should file a review of refusal, namely the necessity to file trademark review. In this part, I will firstly introduce the basis, namely what articles we should base to file the review, and the deadline, and then the three necessities to file review. And the third, also today's most important part, how to overcome the refusal. Actually, there are many reasons of refusal, different reasons. We have different ways or arguments to overcome different refusal reasons. In this part, I will present you some major refusal grounds and how to overcome them. I will also present some cases in this part. Of course, at the end of our meeting, I will leave it to all of you for asking questions, if any. Please hold on for a second. And okay, let's move to today's first topic. What do the examiners exam when they receive the applicant's new application? Before talking about what do the examiners review in the new application procedure, and I'd like all of you seeing the data of new filings. As you can see from this chart, all the quantity of the new filings in recent 5 years, namely from 2018 to last year. And all the recent 5 years quantity have exceeded 7 million. In my cognition, and the number may be on the top of the world. With such huge prayer marks, the new application is likely to be refused by citing prayer similar or identical marks. In addition, namely, in addition to the similar or identical prayer marks, Trademark Office will also examine if the new application violates any absolute grounds, namely, if the new application presents any distinctiveness, if it is forbidden to be used as a trademark, or if it is filed in any bad faith. Based on all the factors, the rate of refusal increases in a very fast way in recent years. Right now, I believe you have already knew why your client's mark in mainland China was easily refused. To lower the chance of refusal, we do suggest our clients to do a clearance search before filing the new application, because from the clearance search, we may estimate the chance of getting registered, or may take actions in advance against the potential risks or the obstacles. So that's why we always suggest our clients to do the trademark search when we receive our clients' consultants before filing the new application. Okay, next I will move to the procedure of new filing. Actually, this is a brief summary of the procedure from new filing to getting registered. Yes, after the applicant filing the new application, the Trademark Office will start to examine it, and it will be refused if there exists any prior identical or similar mark, or it violates any absolute grounds. After refusal, the applicant is entitled to file review in a prescribed time. After filing the review, the case will go to the review department. If we can persuade the examiners, the trademark will also be published for opposition. If not, the applicant still get a chance to appeal before the court. Of course, if there is not any prior similar or identical mark, and at the same time, the new trademark did not violate any absolute grounds, the new application will be directly published for opposition. Without opposition during the 3 publication period, your trademark will be surely approved for registration then, and the time is 10 years. As I just mentioned, the new application will face both relative grounds, namely the prior identical or similar marks, and absolute grounds. For the relative grounds, on the bottom of my slide, it means the prior identical or similar marks, as I just said. And for the absolute grounds, there are several situations, and a trademark, as we all know, a trademark should bear distinctiveness. And that means if a trademark is devoid of distinctiveness, it will be surely refused. as it can indicate the source or the origin of the goods, or who or which company provided the designated services. There are also some other situations which are forbidden, such as containing the country name without permission. The elements containing in the mark will mislead the consumers and so on. If the trademark was filed in bad faith, or the designated goods in non-standard descriptions, it should also be refused. Actually, in practice, the non-standard description refusal frequently often happened in the international application, namely the new application through WIPO and designating the territory protection in mainland China. Okay, after finishing the first part, let's move to part B. Why we should file a review. For the followings, we will talk about why we should file a review. Actually, first is the article basis to file a review. According to Article 34 of the Trademark Law, where a trademark registration application is refused or publication is denied, Trademark Office shall notify in writing form. The applicant may apply to the Trademark Appeal Board for a review within 15 days. For the prescribed time for filing the review, I will further explain in my next slide, and against the decision of the appeal board, the party is entitled to appeal before the court within 30 days from the date of receiving the decision. Here, I'd like to further explain the deadline for filing the review. According to the new rules, all the review applications shall be filed through online platform, and hence there will be 30 days for filing the review, namely from receiving the notice of refusal, the date comes. And there will be 30 days. There will be 30 days for the refusal through the manual system. There will also be 30 days for filing the review application. Okay, next I'll give you the reasons why we should file the review. The first one is the different examination department and standards. And for the new application, there is only one examiner, and for the review, there will be 3 of them. So there is a base of discussion among the examiners in the review procedure, and more fair decision can be made than the new application. Actually, in practice, for the new application, the examiner will mainly engage in the guidelines for trademark examination, and for the review, the examiner will pay more attention to the applicant's arguments, the actual use, sales channels, etc. The review examiners will take more situations into consideration in the review procedure. As trademark examination is subjective, different examiners may have different opinions on trademark similarity, or if a trademark violates any absolute grounds. So the examination in the review procedure or in the review department will be more fair for the applicant. So that's the two reasons why the review is that necessary. As you may know, in China, we apply first to file principle. That means the person or company who or which firstly file the new application will get the mark or will get the trademark rights. To file the review, the applicant can get a prior filing date and prevent the new emerged similar or identical marks from registration. So here is an example. One of my clients, a mark was refused by citing only one prior mark, but he stopped to proceed. In several months, when he would like to start his business in mainland China, he chose to restart the new application and refile it. But unfortunately, the refiled trademark was refused by citing three prior similar trademarks. So it is a pity. So that's maybe the last reason why the review is a necessity. Okay, as just said, part C will be the most important part of our today's meeting. How to overcome the different refusals. Yeah, when we receive the notice of refusal, what should we do? The following is what we will do in our daily work. And first, we need to confirm the deadline to file the review. Without catching the deadline, the mark will be deemed as abandoned and dead. That's why the deadline is that important. So the first thing when after receiving the notification of refusal is to confirm the deadline. So considering the quantity of the new filing every day, the examiner may cite the wrong articles to refuse the new application. So it is also necessary and important to check if the cited articles are correct. If not, we can contact the trademark office to withdraw the notification of refusal and continue the examination. And after checking the cited articles, we also need to check if the cited mark are correct. Why I say if the cited mark are correct is because even if two marks constitute similar marks with each other, but the goods covered by the application mark and the goods designated by the cited mark are different, these two trademark will not be considered as similar trademarks because they are or they will be used in different products or services. So that's why after checking the articles, we also need to check if the cited trademarks are correct. Sorry. Actually, next we always find some similar prior cases to analyze the examination standard to evaluate if our client's refusal can be overcome. Once all the above are confirmed, we will start to analyze the refusal and make a proposal on how to overcome the refusal. Okay, let's go to the specific articles regarding trademark refusal, and the most frequently cited articles are Article 10, Article 11, Article 22, Article 30, and 31. Now let's go to the details regarding these articles. The first one is relative grounds, namely prior identical or similar trademarks. And the related articles are 30 and 31. For the articles specific content, to save time, I would not like to repeat them during this meeting. My PowerPoint will be shared after this meeting, and you can read them by yourself and contact me or our consultants if there is any questions or if there is any doubts. So let's move to the points. And to overcome prayer marks, we also need to do several things in advance. And first, we need to compare the application mark and the cited mark in respect of different aspects, such as the letter composition, design, overall appearance, pronunciation, business scope, etc. If there is still room to argue that there is a similarity between the application mark, and try to persuade that there will not be a confusion for the coexistence of these two trademarks, then a review is necessary. If you want to make sure if two trademarks, namely if the application mark and the cited marks constitute similar marks, you can contact our consultants for a free consultants. Second, we need to see if the owner of the cited mark is still alive. In practice, I met lots of similar situations. If the owner of the cited mark does not alive or the register, it will no longer pose obstacle before the registration of the application mark. There is no chance for the cited mark to get into the market again, and then to raise any confusion among the consumers. So that's why it's also important to check if the owner of the cited marks are still alive or the register ultimately. Third, we need to see if the cited mark has been in registration for more than 3 years, and if the cited trademark has been put into if the cited mark has been in registration for more than 3 years and no user evidence is located online, namely we only need to do a very brief search online to see if there is any clue to prove the actual use of the cited trademark, and we can file the non-user cancellation. The burden of evidence, the burden of proof is on the trademark registrant. Actually, if after we filing the non-user cancellation, the trademark registrant needed to provide user evidence. If failed, then the trademark will be decided to canceled. Actually, the non-user cancellation is a easiest way to try to remove the obstacle or the risk. First, we must check if the owner of the cited mark has business relation with the applicant. According to the Chinese trademark law, without authorization, the agency of the true brand owner is not allowed to file the identical or similar marks? If so, we may ask the owner of the cited mark to assign the cited mark to the applicant or file opposition or invalidation against based on bad faith. Next, we need to search if the cited mark is filed in bad faith. If so, we can file opposition or invalidation against the cited mark. For example, if the owner of the cited mark has also filed many other marks which are similar or identical with other famous brands, it is clearly in bad faith. Lastly, we also need to check if the application mark has been put into use. In practice, the fate of the application mark will also help to increase our chance of success, as the actual use evidence can prove to some extent that there is no confusion in actual use. After finishing the relative grounds, let's move to the absolute grounds. And for the absolute grounds, we will pay attention on Articles 10, 11, and 22. So let's start from the easiest articles we can overcome. Actually, this article can be easily overcome, as I just said, by amending the non-standard descriptions to standard ones. By overcoming such refusal, a review is still needed to keep the mark alive. And after filing the review before the trademark office, or at the same time, the applicant need to file your application before WIPO to amend the non-standard description to the standard ones. As you may know, the trademark office did not accept, actually only, as I know, only China trademark office did not accept the wholesale and the retail service except for the medicine. So the new application slow Mandarin system in class 35 is often refused by citing Article 22. Now let's start Article 11. For Article 11, it relates to the examination of distinctiveness. As we all know, the distinctiveness is the basic requirement for being a trademark. A trademark must possess the function of indicating the origin of the goods or the services. So let's now we will talk about the articles one by one. And first, if the application mark is only a common name or just a device or model number of the covered goods service, it will be considered as devoid of distinctiveness, such as the device such as the device showing on my slide. And when the consumers see this device, they can easily recognize that this is a barber shop, but they can only recognize this is a barber shop. But which barber shop they can't recognize. And so this device can be used as a trademark for lacking distinctiveness in the barbershop stores or brand. Second, if the mark only indicates the quality and new materials, function, purpose, weight, quantity of the goods, and then it will also be considered as devoid of distinctiveness, such as the word beautiful itself. in the cosmetic products and 50 kilogram in the products of rice. As we all know, cosmetic will make you more beautiful in to some extent, which can be seen as a function of the cosmetic products, a function where it itself does not have distinctiveness and can be registered as a trademark. 50 kilogram is only a weight unit which can't indicate the origin of the goods, so it will also be considered as distinctiveness in the relative products. Actually, there are also many other situations which will be considered as out of distinctiveness. Such as if a trademark is conducted by the simple lines or one or two letters without any design, just the letters or single color number without any design, advertisement slogan, all the situations will be considered as devoid of distinctiveness. In practice, to overcome this article, we must provide lots of user evidence to prove that the application mark has obtained distinctiveness in actual use or through a long period use. The public can recognize the origin of the goods or when they see the mark. Actually, in practice, this may be the only way to overcome the distinctiveness refusal. Next, we will talk about Article 10, the forbidden use article. Although there are 8 provisions containing in Article 10, I inclined to summarize these provisions to the following situations in practice, namely the frequently refusal reason regarding Article 10. Also, for the specific content of Article 10, I will not repeat them in our meeting to save time. First, if the mark contains a country name and or any official signs, it shall be refused. As you can see, the left one contains China and the right one contains Italia. Both will be surely refused in the application procedure. But if the applicant can obtain the authorization or permission to use the country name or the official signs, there is still a chance to get approved for registration. But in practice, it is very difficult to obtain such a permission or authorization, or even if we don't know where we can get such permission or authorization letters. So for the trademark which containing a country name, it is always difficult to overcome. Next is about a deceptive and misunderstanding. If a mark is deceptive and at the same time will surely cause misunderstanding among the consumers, it shall be refused. Here's an example. If a company mainly engaged in the canned fruit and the materials comes from the fresh fruit such as pear, orange, apple, etc. But I file a new application of an Apple device, as shown on the bottom. In this situation, the mark will make the consumers a confusion on the material of the canned fruit. So in this situation, misunderstanding may be raised. And in this situation, the new application will be refused. Also, next, if there is a likelihood of confusion on the origin of the goods, it shall be refused. Here is the example. If a Chinese company, as you can see that the mark contains a city name, Paris, on the bottom of the trademark. If a Chinese company filed a mark containing Paris, it will be surely refused, even if the city name was put on the bottom of, even if the city name is not in the distinctive parts. It will be surely refused. There is a likelihood that the consumers may believe or will believe that the goods or service comes from Paris, but actually the company is a Chinese company and other products were manufactured within China. But if the company is a actual Paris company, or the applicant can prove that all the designated goods comes from Paris or manufactured in Paris, there will be a chance of getting registered. Next, if the mark has bad effects, it shall be refused. If a mark contains any bad words or any bad images or some other or some other bad elements in the application mark, it will be refused for bad effects or potential bad effects, such as if you file a trademark which contains a naked person or a national leader's name or any historical events, the trademark will be surely refused. If the mark contains a well-known place name, it shall be refused. But if you can prove that the mark has formed a secondary meaning in use, or if you can prove that the place name only indicates the origin of the goods or service, and the mark has a chance of a registration. The last one, actually, this one is not that often, it's not that frequently meet. And if the company name and company name containing in the trademark are different, it shall be refused. Such as if the company name is Golden Finance Limited, but the trademark containing Golden Bank Limited. In that situation, the trademark will be surely refused. To overcome this refusal, the applicant may change the company name on the trademark and refile it, or just to change the company name. Right now, I think I've talked about all the main reasons of refusal and how to overcome them. So let's see some brief cases I handled before. As you can see, these two trademarks have only one letters difference in the middle. And there is no doubt that they do consider similar marks, and a bare arguments may not work. So in that situation, we choose to check if the owner of the cited mark is alive, or if the cited mark has been in registration for more than 3 years and has not been put into use. In fact, after checking all the details, we confirmed that this cited mark has been in registration for more than 3 years, and no use evidence or no clue of use evidence is located online. So to overcome this cited mark, we suggest our clients to file a non-use cancellation. In the also in the review arguments, we notify the examiner that our clients or the applicant has filed the non-use cancellation, and the cited trademark will no longer pose any obstacle once it is successfully cancelled. And and at the end, the cited trademark was successfully cancelled as the trademark registrant failed to file any use evidence. We received a favorable decision on the review, and our client's mark was approved for registration at the end. Next is about the deceptive and misunderstanding articles. One of my clients filed the new application for marking on living animals essential oil in the products of essential oil, perfume, and cosmetics, and other cosmetic related products. After examination, trademark office held that it may cause confusion of the raw materials for the covered goods, other than the essential oil, namely there may be a confusion of the raw materials on the perfume, cosmetic products. To handle this case, we must prove that the perfume, cosmetics, and other goods also contain essential oil indeed. Once the ingredients are proved by the applicant, the trademark shall be approved for all the designated goods. But unfortunately, my clients failed to provide such evidence to prove that the other goods, other than the essential oil, also contain the essential oil materials or such ingredients. The mark is only for registration on the essential oil products at the end. Actually, if we meet the similar cases, we need to do two things actually to analyze this refusal article. The first one is to confirm if the trademark itself is deceptive on the covered goods. And at the same time, we also need to confirm if such deceptive will surely cause confusion among the consumers. Also one of my clients from France. My client filed the mark Le Mans in recent service, but was refused for containing the famous place name Le Mans. As we know, Le Mans is a city of France. Surely, Le Mans is a city name of France, and the government has not authorized my client to use the city name. Considering this, we will provide use evidence to prove that it has formed a secondary meaning. Namely, the consumers will not recognize Le Mans as a city name, but our client's brand. So to prove that Le Mans has formed the secondary meaning, we have provided lots of user evidence in mainland China. Upon search, fortunately, we found that there are lots of user evidence, including news reports and promotion, etc. And at the same time, my clients also provided me a lot of user evidence provided in previous cases. So in this review, we helped the applicant to overcome the refusal by submitting amounts of user evidence. And in the decision, the trademark office claimed that the mark has obtained a certain reputation in China and has formed a secondary meaning, and no confusion will be caused. Actually, that's all I would like to share today. So if there is any question, you're always welcome to contact me or our consultants. We will try our best to provide the most professional services for any of our clients. So the next time I will leave it to all of you if there is any questions during the whole meeting.
Okay. Hi, Frank. Thank you so much for performing this demonstration. And this reminds me of the time when we have video meetings with clients together, talking about any possible actions against the trademark objections. Please do have a break. And your efforts of preparation as well as the presentation is appreciated. Thank you, Frank. And now may I ask if, okay. And now may I ask if there's any questions that you might want to directly communicate with Frank? If so, please feel free to turn on your mic and speak to us directly. Okay, well, I see there is no questions for now. Please do feel free to contact if you need any help to your key persons here. So, well, I believe China is probably the most sophisticated jurisdiction around the world in terms of trademark issues. Supposing you have had and you will have any issues to tackle here, please do not hesitate to contact your key person in our firm. And Gaowo is always your go-to professional, and Mr. Frank always has your back to support. I see time is up here, and please accept our sincerest gratitude towards your time and attention. We have other plans of trademark squatting, oppositions, invalidations, or even litigations to talk about during the rest of the year. Of course, we're awaiting for your constant showing up in our salons or seminars. That's all for today, and we need to say goodbye. My fellow colleagues, have a nice dream there or nice day there, and we will see you next time. Bye-bye.
Okay, bye-bye. Thanks for all your time.
Bye-bye. See you next time.伊藤さんお疲れ様でした。 伊藤様、それで失礼させていただきます。